Our next speaker is Kevin Zielke, a trial lawyer from Dykema in Detroit, Michigan. He focuses on complex litigation involving science and medicine, drugs and medical devices. He leads the firm's pharmaceutical team. Kevin will discuss pre-litigation preparedness for in-house counsel and using time-segment-based strategies. Please welcome Kevin Zielke.
I have to apologize. I was a bit embarrassed by having Jesse run that video of the dep I was defending. You know, we all have bad days, and that puppy just got under my skin. What can I say? Given what I know from 14 years of network experience about the knowledge and the experience that's in this room, I'm certain that everyone here at one time or another, upon finding themselves immersed in Thunderdome-style litigation, has picked their weary head up off the stack of documents that's on their desk, has rolled their eyes toward the heavens, and has thought, if only, if only the damning email hadn't been sent, if only we'd gotten our hands on that critical file before we had to respond to the complaint or before we had to respond to the media requests for comment. If only our company witnesses were better, were more litigation savvy. If only we'd had some inkling that this would happen. In short, if only we'd been better prepared before we got ourselves into this mess. So my objective this morning in the short time I have with you is to talk about developing a checklist of to-do items that will help you reduce the number of if-onlys you find yourself rattling off when litigation rears its head. Before we dive into specifics on the do's and don'ts, but let's talk a little bit about adopting the right mindset. So, if you think about the typical arc that litigation follows, you'll see that it generally divides into three distinct phases. If I was better at PowerPoint, this would actually be a circle, so it would show the cyclical nature of this. But essentially, you've got a pre-crisis period that rolls into a signaling event that signals the beginning of a crisis that then goes on to the associated litigation, and in my world, often regulatory proceedings. Rather than recognizing this cyclical nature, however, many of us tend to adopt a binary mindset when it comes to litigation. We're either on, meaning we're actively involved in litigation on a particular matter, or we're off, and that means that we're not. A byproduct of this binary mindset is that during off periods, planning and preparation for the next on period tends to drop down the priority list, sometimes even off the priority list, and that leaves us not nearly as well prepared as we'd like to be when the next crisis comes. Adopting a cyclical mindset is a reminder that you're always on your way to your next piece of litigation, and in that way helps to make sure that you're prioritizing preparedness. So here we are in the pre-crisis period. It reminds us a bit of where we are today. In considering appropriate steps to take during this period, it's best, again, to start out by making sure that you have properly oriented yourself toward the problem. Another byproduct of the binary mindset is that litigation seems to feel like a bolt of lightning, like a sudden, acute event that catches you and your company by surprise. The reality is that litigation and where that litigation ends up falling on the risk spectrum is typically the result of problems that are allowed to incubate within your companies rather than due to some sudden conflagration. Preparedness efforts during the pre-crisis period involve identifying where this incubation might be occurring and doing away with it. But how do you know where to look? There's no upside to activity simply for activity's sake. This is for people who are looking to create the impression of preparedness rather than actually being prepared. So to get the kind of buy-in you need from company personnel for these efforts, you have to show a solid connection between the pre-crisis efforts you're asking them to engage in and potential litigation risk. To do this, you have to know your enemy, which means you have to see the world through the eyes of plaintiff's counsel. Jesse's slide on keep calm and embrace the dark side struck me with this particular point. Fortunately, plaintiffs' attorneys typically are not the most complicated creatures. Their main objective is simply to convince the jury that the company greedily put profits over safety, or over integrity, or both, and as a result is deserving of maximum economic punishment, and they're asking the jury to inflict that punishment. That's why plaintiffs' lawyers typically approach personal injury and the mass tort matters that I get involved in, typically mainly as company conduct cases. They don't look at them as science or medical cases. They use as little science and expert and medical information as they can possibly get away with. They want this to look like this is a bad company, you should move money from them to my client. Meanwhile, unfortunately, we tend to respond on the other side simply by pulling in the opposite direction, and that is making these cases so much about science and expert witnesses and medical information that often jurors come away with the sense that we're attempting to hide behind a wall of retained experts, and it only feeds into what the plaintiff's lawyers are trying to accomplish. So if the principal objective during the pre-crisis period is to address issues that left unchecked and allowed to incubate will provide plaintiffs with evidentiary fuel they rely on to paint the company as villainous, then we need to look at it from a pre-crisis standpoint at trying to alleviate those issues. First one, and Joe Ortega touched on this earlier with respect to cybersecurity, is the idea of establishing a crisis management plan and a crisis communication plan. There is a difference, and Joe even touched on this analogy, there is a difference between knowing in your mind that you need to get out of the house during a fire and having a set plan to do that, how you're going to go about accomplishing it. And that's what I'd encourage everybody here who doesn't have one to do. It's essential that you formulate, review, and regularly update a company crisis management plan. In the event of a crisis, who do we assemble? What are their responsibilities? How are requests for information from the media or from regulatory authorities routed and handled? All of these SOPs and many, many more need to be spelled out in advance. This is the time for your company to turn into SEAL Team 6. This is not the time to turn into the Keystone Cops. Outside litigation counsel, I would say, should be a member of this crisis management team. This brings a litigation sensitivity and a litigation judgment to the process at an early stage and fosters the type of enterprise mentality I hear a lot of in-house counsel talking about wanting to foster with their outside counsel. Moreover, in my world, in terms of lining up and preparing the best experts, this gives you an inside lane because delays in that area, especially in a multi-defendant lawsuit, can be costly if you lose out on the good experts. Secondly, establish a litigation hold policy and process. Plaintiffs' lawyers are looking for every loose thread in terms of company conduct, and this is one that they really love to yank on. You didn't institute the hold fast enough, your policies weren't good enough, you didn't adhere to those policies. Now, we exist in an interesting era right now before the Rule 37E amendments are enacted, but while they're pending. So it's hard to know what the world is going to look like after Rule 37E is fully enacted. During this time, I would say it's simply critical to have an established litigation hold policy that passes the reasonableness test, and that's one you have a demonstrated track record of adhering to. Conducting annual legal risk assessments. In these times of increasing convergence and increased creation of preferred provider lists, that was hard to say. Even in my practice sessions, preferred provider seemed not to roll off the tongue. Or certified counsel lists, those types of things. These are the client service opportunities that outside counsel should be jumping at, and that inside counsel, in-house counsel, should really be making the most of. Conducting these annual legal risk assessments provides a unique opportunity for people to learn about the company, to solidify relationships within the company, and to position yourself as an outside counsel well should any of these identified risks actually turn into crises. Reviewing lessons learned and holding practice sessions. Just like athletes don't become great by playing only during games, company personnel don't develop strong litigation muscles by only exercising them during active litigation. Every piece of litigation should be followed by a lessons learned session to identify what worked and what areas could be improved. Also, I'd encourage companies to enlist the help of their outside counsel to develop hypotheticals and to run scenarios to help your crisis management team and other key personnel sharpen their response tactics and build up their level of litigation savvy. Conducting annual insurance reviews. This is really self-explanatory. You just don't want to become aware of gaps in your coverage after litigation's been brought. And then the coordinating and facilitating frequent communication. To me, this is the number one area to shine a light into. These are the poorly lit corners where incubation takes place. And the way to stop that is by fostering a culture of communication within your company as opposed to one of isolation. This can be done by adopting policies and procedures that mandate information sharing and that create an atmosphere of group-to-group accountability and then monitoring to be sure those are adhered to. If this is done and you still find issues arising, typically you can present this as a rogue employee who ignored well-established policies and procedures. This, while not optimum, is much better than the situation you confront if you have no policies and procedures in place, or if there are simply paper policies and procedures that weren't adhered to or followed. The biggest fear of in-house counsel is that executive management and their board is caught by surprise. So, of course, getting in front of risks before they materialize is important. Outside counsel, again, can be of great assistance in this area, but I would encourage my outside counsel comrades that less is more in this area. In-house counsel, as we know, are under greater and greater pressures, and lengthy dissertations and long newsletters aren't necessarily the way to keep them informed about impending risks. A simple short summary and letting them know that you're available to talk if they want more information should really do the trick. And then lastly, ensuring access to key information. This should be done, in my view, by putting together succinct, in case of emergency, dossiers on all products and on all major deals that you go through. These dossiers, which should be put together and should be retained by outside counsel, should at a minimum include a list of the key personnel and a summary description of their roles, copies of critical documents, a timeline of events, and a working document that lists any issues that were identified during the legal risk assessments that I mentioned earlier. So a signaling event is the dividing line between the pre-crisis and the crisis periods. That's all it is. And in general terms, it's really any event that would reasonably create an anticipation of litigation. In my world, in the products world, and in the medical device and pharmaceutical world, these are the types of things that I consider potential signaling events. However, I'd say that in this time of wide data availability, plaintiffs' lawyers, I've noticed, have begun teaming with consultants to generate their own signaling events or to push regulatory to action to create a signaling event. The crisis has arrived. Before going over the specific to-do list you should be covering during this period, it's important, again, that we first consider the environment we now find ourselves in once the crisis period has begun and how that might affect the factors that I've talked about that drive litigation risk. During the pre-crisis period, as we discussed, there's a baseline risk of poorly thought-out company conduct that plaintiffs' lawyers use to bolster their bedrock theme that the company values profits over safety and integrity. The onset of the crisis can have a hothouse effect on this baseline risk. Like water molecules that begin moving at increased speed and with an increased risk of collisions when heat is applied, company personnel, when confronted with a crisis without well-established plans for how to handle it, begin acting in what they perceive to be the best interest of the company, which may not, in fact, be the best interest of the company. Or worse, they begin acting in their own self-interest with a desire to CYA. Our pre-crisis activities are an effort to decrease and to diffuse the level of heat that's created by crisis onset. Our crisis activities are an effort to quickly formulate core themes and theories and to maintain consistency within the company on these themes and theories. During the crisis, inconsistency, either in messaging or in conduct, is the real enemy. So here's our crisis checklist. The first two items on this list focus on creating the privilege bubble and bringing the key company personnel inside of it. These foundational steps are essential to the remaining items on the list. Lou's presentation this morning, I thought I had some interesting ideas on things you can do to help protect the privilege, such as making clear who's speaking in the minutes and in what capacity. Developing unassailable science-based messaging in the products liability environment, assessing the available science and data and formulating the most easily understandable and unassailable science-based messaging is critical. Internal company personnel, external consulting experts should be a part of this process. It's crucial that you develop quickly a very high degree of confidence that you'll be able to stand by this messaging throughout the litigation. This is not an excuse that many lawyers hide behind to waver or to use soft or equivocal language in your messaging. This is not the time to be gun-shy. If you followed the pre-crisis protocol, you should have access to all the information you need to be resolute in this foundational and fundamental messaging. Once you've developed that messaging, your internal and external communication strategy will tell you how to roll that message out both within your company and to the outside world. Assessing the scope of relevant documents and data and issuing a litigation hold, it's now time to implement that hold policy that you've worked so hard on as part of the pre-crisis period. Monitoring crisis communications for consistency with science-based messaging. In the pharmaceutical and the med device world, where the departments have very clear scopes of responsibility, you can have a lot of inconsistent messaging that comes out. When you have drug safety responding to a request, regulatory responding to a request, sales and marketing responding to a request, this creates the proverbial different hands on the elephant, and those are exactly the kinds of opportunities that plaintiffs' lawyers are looking for to show that the company doesn't really care about the people who are using its product. So in terms of monitoring these communications, especially any press releases, draft Q&A, sales and marketing documents, and any regulatory submissions, those should be reviewed by a defined small group of outside counsel to ensure consistency. And then the final 2 points are really meant as a way to try and help protect the perimeter by ensuring awareness of the risk of related types of legal and regulatory proceedings. So as cases are filed and regulatory proceedings are scheduled, the battle lines begin to come into sharper focus, and the tumult that you experienced in the crisis period starts to take on a greater sense of process, a greater sense of order. It's amazing. It's always amazing to me, after all the years of doing this, that what was so extraordinary eventually becomes the ordinary, and you assimilate it into your everyday life. That's when really the results of the effort expended during pre-crisis and during crisis periods comes to fruition. And in terms of those benefits, as I see it, you find yourself at the end of that process with unassailable scientific and medical themes that allow you to have consistent and accurate messaging in all forums based on those themes. You have a response that you're prepared to offer that mutes any attempt to portray the company as a bad actor. You're out front on expert retention and preparedness, and your outside team is fully versed in all relevant facts and data, and you have a relationship of trust and confidence between outside counsel and in-house personnel. Success in the litigation phase is driven by a willingness to try cases. Going into litigation without a willingness to try cases is guaranteed to maximize the costs of resolution. To be willing to try cases, you need to have complete confidence in your fundamental themes and theories, and you need to be able to tell the best possible company conduct story. With this two-track approach, you diffuse plaintiff's lawyer's main offensive weapon while landing your own devastating blows. So with this in mind, hopefully you can shorten that list of if-onlys. Thank you.